Georgia's PFAS Receiver Shield Act faces procedural reset. Georgia's proposed PFAS Receiver Shield Act, HB 211, has been withdrawn and recommitted in the House, signaling that lawmakers are taking another look at how and whether to grant liability protections to certain downstream users of per- and polyfluoroalkyl substances, PFAS. The bill, introduced in January 2025, had advanced with a committee substitute before being pulled back for further consideration on February 11, 2026. While procedural, the move underscores how sensitive PFAS liability has become, not just for manufacturers, but for companies that handle, use, or dispose of these chemicals as part of otherwise regulated operations. What the bill would do, at its core, the legislation seeks to draw a distinction between companies that manufacture PFAS chemicals and those that receive or use them in the course of normal business activity. Under the proposal, PFAS receivers, broadly defined, would be granted immunity from certain tort claims related to the intended or incidental use, receipt, or disposal of PFAS, provided their conduct does not rise to the level of gross negligence. Plaintiffs would be required to plead gross negligence with specificity, and courts would determine whether that threshold is met. The substitute language also reinforces that PFAS receivers who comply with federal and Georgia Environmental Protection Division regulations, particularly when disposing of industrial effluent or solid waste, would not be held liable for damages arising from those regulated activities. In practical terms, the bill attempts to protect entities that are operating within existing environmental rules from being swept into expanding PFAS litigation. Who qualifies as a PFAS receiver? The definition of a PFAS receiver is broad. It includes entities that use PFAS in manufacturing or agriculture, purchase or incorporate PFAS-containing goods, operate licensed landfills, manage wastewater that may contain PFAS. Importantly, the bill distinguishes these entities from PFAS manufacturers, companies that created or originated the chemicals into commerce. The proposed immunity would not apply to manufacturers. For industrial operators, municipal waste handlers, and companies incorporating PFAS into finished products, the distinction is significant. It signals a legislative effort to separate chemical originators from downstream users acting within regulatory frameworks. What the bill does not shield. The legislation is not absolute. It does not protect conduct that qualifies as gross negligence, limit enforcement authority by the Georgia Environmental Protection Division, override criminal statutes, public health laws, or emergency management statutes, eliminate any duty to warn under common law. Personal injury claims remain possible under defined circumstances, and regulators retain full enforcement authority. That structure reflects a balancing act, offering some liability certainty for regulated operators without dismantling oversight or eliminating accountability. Why this matters? PFAS litigation continues to expand across the United States. Municipalities are seeking remediation costs. States are pursuing recovery for contamination. Private plaintiffs are filing personal injury claims. Even companies that did not manufacture PFAS are increasingly being named in lawsuits. For operators that rely on regulated waste disposal systems or that incorporate PFAS-containing inputs into production, the legal environment has grown more complex. Insurance markets have tightened. Disclosure expectations are increasing. Risk modeling has become more difficult. Georgia's proposal reflects a broader policy question emerging nationally. Should downstream entities that complied with environmental regulations face expansive tort liability for substances they did not create? Supporters argue that regulated compliance should carry some protection. Critics caution that immunity provisions could narrow legal recourse for affected communities. The recommitment suggests lawmakers are still navigating that tension. What happens next with the bill returned to committee? Revisions remain possible before it advances again. No liability shield is currently in effect. For companies operating in Georgia, particularly in manufacturing, agriculture, wastewater treatment, and waste management, the bill remains worth monitoring. Even if the language changes, the debate itself signals that PFAS exposure and downstream liability will remain active policy issues in 2026. This latest action does not end the conversation. It reinforces that the legal boundaries around PFAS responsibility are still being defined, and that regulated compliance alone may not fully resolve exposure questions in every jurisdiction. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.